All right.
The last name.
All right, fantastic. But Brian, before I get your name and your date of birth, a county attorney is appearing in this case to make some arguments to the court. They have the right to do it, but I need her appearance first. So Ms. Thompson, go ahead and make your appearance.
Thank you, Your Honor. Ledger Thompson for the state.
All right. And Mr. Affinito, can I have you tell me your name and date of birth?
Brian Affinito.
So much, sir. Okay, so let me tell you why you're here first, and then the county attorney has some arguments that it wants to make to me. But you're here on one count of attempted robbery, a Class 5 felony, allegedly occurring on May the 25th. Now, you will have a court-appointed lawyer to defend you throughout this case, and that lawyer will attend any court hearings that you may have, okay? Now, Ms. Thompson, my understanding is you want to make an argument on probable cause, and then if the court finds probable cause on release conditions, correct?
Correct.
All right, so go ahead with your probable cause argument.
Thank you, Your Honor. The essential elements of attempted robbery, which Mr. Affinito has been charged with, according to State v. Williams, which is a 2013 Arizona case, are twofold: intent to commit a robbery and an overt act towards the commission of that offense. Intent is a critical element that can be inferred from the circumstances surrounding the act. Here, the facts allege that in the middle of the summer, or I guess at the beginning of the summer in Arizona, during normal business hours, Mr. Affinito entered a bank for which he is not a customer. He was wearing a black hoodie with the hood up, black sunglasses, and a black face mask. He placed an empty bag before a young teller and demanded all of their 100s and 50s. The second element is the overt act. Here, the overt act was the demand for money, which moves Mr. Affinito's actions beyond preparation and shows an advance towards commission of the crime. In State v. Clark, which is a 1984 case, the court held that even if a person does not physically harm or threaten anyone, the act of demanding money in such a manner could be perceived as such a threat. Here, we not only have the demand for 100s and 50s to the bank teller, we also have him disguising his appearance in order to effectuate the crime. And so for those reasons, Your Honor, probable cause is a low burden of proof, but we believe we've met the burden of proof that there is a strong suspicion of guilt that he has committed the alleged offense of attempted robbery. Thank you.
All right, so I have a couple of questions for you, Ms. Thompson. With respect to State versus Clark, that case, was that a robbery case?
It was.
All right, so you're saying that because I've not read that case, and I don't have a problem going back and reading that case when I get back to my office, but you're saying that that case addresses the issue of whether or not a defendant, hold on, let me make sure I state the element properly here. So that case addresses the element of whether the defendant either threatens or uses force against any person with the intent to coerce surrender of property or prevent resistance. That's what that case addresses, is that element of robbery, is whether there was some type of an overt act to threaten or use force with the intent to coerce. And you're saying that the act of just demanding money can be inferred as a threat of using force or coercion. That's what I want to make sure.
Well, I'm saying that you can look at the totality of the circumstances from both of those cases, that the inference of a threat does not necessarily have to be from an actual threat, that you have to look at the circumstances, and that's what Clark is indicating, that it's fact specific. And here, as I indicated, we have specific facts that can be perceived as a threat.
Yeah, but I want to know what are the facts of Clark. Clark is a robbery case. So the defendant makes a demand for money, And the Court of Appeals, because is this a Court of Appeals case or Supreme Court?
It's a Court of Appeals case.
So, okay, so the Court of Appeals makes a finding that the court can infer or a jury can infer from a demand of money under the totality of the circumstances that there is an intent to threaten or coerce somebody to surrender property.
Correct.
All right. Here's where, and in that case, the facts were just a demand for money.
That case.
Or was there something more in that case other than just a demand for money? And I'm just not familiar with the case law, so I'm relying on you to let me know what the facts are.
Just give me 1 minute, Your Honor. I apologize.
And while you're looking at it, let me tell you what my concern is. My concern is with respect to inferring a threat or using force or coercion from somebody, is in this particular case there was no express threat of any type of harm to anybody. It was just give me your hundreds and your fifties. I don't know how threatening under the circumstances this was, because I don't know if the bank teller are they behind some type of a bulletproof glass type of a partition? Are they directly in harm's way? But what concerned me is that another bank employee walked right up to the defendant and said, "Can I help you, sir?" Meaning, and in my mind, I'm trying to put this together, whether there was some, can I infer some type of a threat or coercion under the circumstances. I'm struggling with that when under the Form 4, another bank employee approaches this person and says, "May I help you?" or something to that effect.
And I hear what you're saying, Your Honor, but I would argue that it was the other bank employee that sort of thwarted Mr. Athenito's intention. That this probably happened in rapid time, and so sort of the interference by that other employee is what led him to abruptly end his intent to rob and flee the scene, basically.
That could be. I mean, there's a possibility that something could have interfered with the elements of the crime, but that's what I'm worried about, is that. So tell me a little bit more about the facts of Clark.
So, I mean, Clark there's many more. There's a gun involved and a stocking cap.
Say no more.
So that
say no more. Yeah, say no more. Okay. At the present time, I will let the state file a direct complaint if they want to proceed with this case. I'm not going to find probable cause here tonight. I'm not saying that there isn't sufficient facts or that another judge reviewing this might find probable cause. I'm just a little concerned whether or not, considering all of the facts, and I know I can consider everything. I can, the totality of the circumstances, and even including what he was wearing or whatever, which it was obviously the allegations are as he was trying to disguise his appearance so he wouldn't be caught. But I am just having a hard time with the force or coercion element. If this was a theft attempt, I don't think I'd have a problem getting there. I think the robbery, that additional element in robbery has given me just a little bit of concern. So I'm not going to find probable cause, Mr. Athenito, for purposes of tonight on the robbery charge, but you're not out of the woods, okay? The fact is the state still has time to file a charge against you formally through a direct complaint, and another judge may look at these circumstances and disagree with me and find probable cause under the circumstances. Or the police may have more information than what I have available for purposes of finding probable cause tonight. So you're not out of the woods. You're going to get released from custody, but I'm going to make sure you have a lawyer, and I'm going to give you some court dates. And you will need to attend these court dates: Superior Court, downtown Phoenix, South Court Tower, Thursday, August 22nd at 8:30, and Monday, August 26th at 8:30. Those are your court dates, and you need to show up just to make sure that charges have not been filed against you. Right. And it might not even be robbery. They may file other charges against you that have, that may be related to the event, but maybe some other offenses, okay? Okay. So it's important you show up because, like I said, you're not out of the woods. All right, Ms. Thompson, any other matters you want to address on this case?
No, Your Honor, thank you.
All right, thank you. All right, Mr. Affinito, you'll have your paperwork right there on your way out. There's a telephone number for the court to be found in there. Okay?
Thank you.
You're welcome. All right. All right, Sheena Smith. Hi, Sheena. All right, Sheena, can I have your name and your date of birth?
Sheena Smith. And
thank you. All right, so Sheena, you're here on two matters. You did pick up a new charge. We're going to talk about that first, and then you're here on a fugitive warrant, and this is out of Texas. We're going to talk about that in just a second. Now, with respect to your new charge, dangerous drug violation, class 4 felony, you will have a court-appointed lawyer to defend you. Your hearings on that charge are here in downtown Phoenix in Superior Court in the South Court Tower, and they are going to start next week. Tuesday, August 13th at 8:30 is your status conference, and Thursday, August 15th at 8:30 is your preliminary hearing. $50 is your bail on your new charge. Now, with respect to the fugitive of justice matter out of Texas, so Texas has a valid warrant. We had to get it validated, and they want you back on that warrant in Oldham County. So I don't know anything about the substance of that charge or why the warrant issued. All I know is it's a valid warrant. They want you back on it. So we're not going to talk about the substance of that charge. We're going to talk about your extradition. That's the process of sending you back from Arizona to Texas. Now, there's a number of rights that you have with respect to your extradition, and that's what that white plastic card was intended to inform you of. Did you have at least an opportunity to review it?
I read it, but I don't really understand what it means.
Well, I am going to go over it. That's my job, is to go over it to make sure that I can try to explain it the best I can so you do understand. Because there is a decision you have to make with whether you want to exercise your rights or whether you want to waive your rights. So let's talk about what those rights are, okay? So if there was any reason that you wanted to challenge that warrant for whatever reason, you have the right to have a hearing here in Maricopa County Superior Court in downtown Phoenix, and that would be on Monday, August 19th at 1:30 in the afternoon. Now, you have the right to be represented by an attorney at that hearing, but I can't appoint one to represent you because the process of sending you back, that extradition, it's not criminal in nature. We only appoint lawyers in criminal matters, and the process of getting you back is more like a civil matter. Now, there are public defenders that attend those hearings. You could talk to a public defender, but if you wanted a lawyer, you'd actually have to retain your own, okay? Now, you've got the right to bail, and we're going to have to reprint this one out. You do have the right to bail. It would be $10,000. And that would be secured. In other words, you could use a bail bonding company to help you post it. And you have the right to force the governors of both states, Arizona and Texas, to sign a governor's warrant to have you sent back, okay? Now, the process takes between 60 and 90 days, meaning if you're not able to bond out, you do have to remain in custody for that full amount of time, which is the 60 to 90 days. Not only that, I don't know whether or not you will have resolved your Arizona case within the first 60 to 90 days either, because I don't know if you're going to fight it or not. So that's what your rights are. The right to have a hearing, August 19th at 1:30, the right to hire your own lawyer at your own expense, the right to bail, $10,000 secured, the right to force the governors of both states to sign a warrant before you're returned, and the process takes between 60 and 90 days. Those are your rights. Now, you can exercise them or you can waive them all. And what that means is basically telling Texas, hey, just come out and get me. I'm ready to come back. If you make that decision, you're giving up all of those rights to the hearing and the bail and all that kind of stuff, and I have to hold you non-bondable. Starting right now, you'd be held non-bondable. You can't leave custody, and you'd have to remain in custody for a period of up to 30 days, and that 30 days will start as soon as you resolve that Arizona charge that you picked up, that drug charge. Now, I don't know how long that's going to be. You could resolve it right away, or it may take you a while to resolve it because I don't know if you're going to fight it or not. But you're non-bondable. And the reason why is because if you're going to voluntarily go back to Texas, they need to know exactly where you're at, and that's going to be in a Maricopa County jail cell, because if they're going to send people out here, they need to know exactly where you are. So I'm here to answer questions if you have any about what your rights are or waiving your rights or whatever, but a decision has to be made. Now, the other piece of information I'll tell you is if you waive your rights here, you can't change your mind later on and say, no, forget it, I want my hearing. However, if you ask for your hearing and you don't waive your rights, you can always change your mind and say, I want to waive my rights later, okay? So you waive your rights, it's over. If you don't waive your rights, you can change your mind later on. Any questions about the process? It's about everything I know at this point in time, because I've never covered that court, those type of hearings before, but I'll do my best if you have questions.
Well, either way, I have to remain in custody, though, right?
You're either going to, the only way that you would be able to get out is if you don't waive your rights and you're able to post your $10,050.
I don't know. What do you think I should do?
I can't give you legal advice, ma'am. I'm so sorry. I will tell you this. If you don't know what to do, if you're just not certain, remember what I said. If you waive your rights, you can't change your mind later on. If you don't waive your rights, you can change your mind later on. In other words, you have more flexibility if you don't waive your rights, okay? I can't tell you what's in your best interest at this point in time. You haven't even met with your lawyer yet to find out anything about how quickly you could resolve your Arizona charge. So at this point in time, it's really between you and your lawyer.
Then we'll do the first one.
All right, so you do not want to waive your rights. You want to have the flexibility to determine later on what you want to do. Okay, understood. So that's what the court will find. We'll set a hearing for you August 19th, 1:30 p.m., downtown Phoenix Superior Court. Your bail is set at $10,000. It is secured. It will allow you to work with a bail bonding company if you need help to post it. If you bond out, make sure you make all of your court dates. Otherwise, you do risk losing your bail money and getting a warrant. No weapons, no alcohol, no drugs. And do you have any questions for me? All right. You'll get your paperwork here in just a second. And I'm sorry I had to reprint that out. I made a mistake on the bond. So,
do I leave this somewhere?
You can just leave it right there. That's fine.